electoral laws. 2, it is now clear that the same criminal enterprise that perpetuated the fraud in the August election is firmly in charge of the Commission and setting up even more lethal mechanisms to defraud the Kenyan voter. The conservative wing of the IEBC have now firmly crystallized their stronghold of the operations of the Commission, with every decision of the chairman being countermanded and with the proposed amendments to the electoral laws to dilute the powers, authority and standing of the chairperson of the Commission as the returning officer of the presidential elections. 4, this is coupled with the retention of the same service providers that were complicit in the worst electoral fraud ever witnessed in modern times, including Saffron, OT Mofo, and Al Ghurair, etc. 5, the Commission CEO, who was the coup plotter in chief, and his litany of senior secretariat staff continue to dominate the operations of the Commission and stifle any attempt to initiate reforms at the Commission. It is now evident that Jubilee is firmly in charge of IEBC through 4 commissioners who have set out to implement the Jubilee agenda within the Commission. Let me say something about the Jubilee administration. 1, the ill-conceived amendments to election laws are not only unconstitutional, but go against international best practice, that in the middle of an elections contest, one cannot change the rules and put in place rules that seek to favor him. Moreover, these profound changes to the electoral architecture are being pushed through without the broad consultations as required by the Constitution. Furthermore, it is clear that the amendments are intended to legalize and regularize the illegalities that led to the invalidation of the August 8th election. It stands to reason that the motive of these elections is to use the same tactics to rig the scheduled election. The state has, in the period intervening the nullification of the August 8th presidential election, gazettement of fresh and pending of the 26th October elections, withdrawn security to the NASA presidential and deputy presidential candidate. This has made it untenable for the candidates to campaign freely without fear of being harmed. The state has done this well aware that under Article 138(8), subsection B, a presidential election would be cancelled if a presidential candidate or his deputy dies. Let me come to the position of vacating the election as the only route to a free and fair and credible election. The IEBC published the Gazette notice declaring the fresh dates for the presidential elections with the Right Honorable Raila Amolo Odinga and Uhuru Muigai Kenyatta, based on the Supreme Court decision of 2013 on a question brought for direction by Attorney General, who is a Chief Government Legal Advisor. In paragraph 289 and 290, the Supreme Court found as follows. I start with 289. It is clear that a fresh election under Article 140, subsection 3, is triggered by the invalidation of the election of the declared president-elect by the Supreme Court, following a successful petition against such an election. Since such a fresh election is built on the foundations of the invalidated election, it can, in our opinion, only involve candidates who participated in the original election. In that case, there will be no basis for a fresh nomination of candidates for the resultant electoral contest. 290 now. Suppose, however, that the candidates or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date. Then the provisions of Article 138(1), subsection B would become applicable, and with fresh nominations ensuing. As per a correction issued on 6th May 2013, the Supreme Court clarified that the relevant article is above is 138(8), subsection B, which deals with the cancellation of a presidential election in the event of the death of the president or the deputy or before the scheduled date. On or before the scheduled date. The Supreme Court finding expanded this clause to include when a candidate withdraws from the presidential election. The implication of this provision is that upon our candidate's withdrawal, the election scheduled for the 26th October stands cancelled. Our withdrawal from the election requires the IEBC to cancel the election and conduct fresh nominations. The procedure for nomination of presidential candidates is provided for in the Elections Act 2011, Section 13, subsection 1, which states, a political party shall nominate its candidates for an election under this act at least 90 days before a general election under this act in accordance with its constitution rules. It is clear that this provision gives adequate time to undertake the reforms necessary to conduct an election that is in strict conformity with the Constitution, the relevant laws, and the Constitution. This being the case, it is our conviction that the withdrawal of our candidates is in the best interest of the country and a win-win for everyone. I now pass back to the Right Honourable.
This is just to show you that we have formally written a letter to